I'm going to talk to you today about claims processing. And for those of you who've been an auditor for a while, this may seem pretty elementary to you, but in going through and preparing for it, I refamiliarized myself with some things that I had sort of forgotten about why we do certain things, and I think it might do the same thing for you. So even though this is part of our Back to Basics presentations that we try to do a little bit of each session and each conference that we have, I hope that not only for those of you who began last year or more recently, but also for those of you who have some experience, you might find this helpful in going back and evaluating why you do the things that you do and how to make things the most efficient that you can. I would really encourage you to take this presentation back with you to your offices and help your claims deputy to build a manual for themselves of how we process claims. All the information that we need, whether it be from these laws that we're going to talk about, and they copy them and put them in a 3-ring binder, whether it's some cheat sheet information about the Uniform Compliance Guidelines and what steps they should do when, or if they just have unusual claims that are, for instance, for travel to a state-called meeting, travel to a meeting that's not called by a state agency. Those kinds of things can sometimes be confusing. The deputies often get in their head that certain things can't be purchased. We have the same problem with field examiners. They can get in their heads that, oh, food can't be purchased. Well, of course food can be purchased, but it has to have a business purpose. And therefore, food purchases can be a red flag, something you want to look at if they go way up from where they were. But it doesn't mean you can't purchase food. There's times when we're at these meetings, if we let 350 of you out on the streets of New Albany to try to get lunch in an hour and get back here, we would have just lost 350 people for the afternoon. So as much as those restaurateurs and bars in New Albany might like to have some additional business, we really can't do that in a business meeting. Some of your county seats would be the same way. You would flood every restaurant in town and still wouldn't be able to get people back in for an afternoon session if you didn't have some kind of a box lunch or something catered in for a business meeting. It can happen. And it can be appropriate for your situation. And we just have to make sure that we understand what the true claims laws are, what our audit responsibilities are, and what our documentation responsibilities are. And so that's why I'm hopeful that maybe you can go back and build some kind of a standard operating procedure manual for the claims deputy. These are the basic claims laws that I'm going to talk about as we go through this presentation. Please do learn how to use the codes. Those of you that have been around a while, you know you can't live without looking at code. You may not have chosen to be an attorney. You're not attorneys. I'm not an attorney. But I read code all the time, and I find it the only way to survive. And so I think you will too. When you see these codes up here, if you look under Audit of Claims, you'll see that Indiana Code 5-11-10-1.6 is listed. The 5 is the title, the 11 is the article, 10 is the chapter, 1.6 is the section. And to the extent that we start getting parentheses and letters and numbers within those parentheses after that, we have subsections. Okay. Don't fear this stuff just because the county attorney, seems high and mighty. They might be, but you can read it too, and read it for yourself, and then get some help with how you might want to apply that in your office and in finding out to the extent that the county attorney is willing to go to bat for you if someone objects. So just keep that in mind as we go through this. First thing I want to talk about is claims procedures. What the law tells us is that a person who has a claim against the county shall file an invoice or bill with the county auditor. And then it also goes so far as to say the county auditor shall present the invoice or bill to the executive, which shall examine the merits of the claim. And then the executive may allow any part of the claim that it finds to be valid. There's a lot of confusion about this because I don't know, I'm sure you've had times where someone brings you a claim, it seems inadequate in its documentation or inappropriate for the fund that they want to spend from, or they lack appropriation, and you tell them about it, and they tell you that you don't have authority to deny a claim. Well, this is the part that they're trying to get you to use. There are things that you can do, and it is your job, as you'll see in later statutes that we're going to talk about, that you audit those claims and that you make sure that there is certain items that are documented within that claim. But this law does tell you you have to present it to the Board of County Commissioners. So that's what they're talking about. Yes, the commissioners are the ones that have to allow or deny any part or in full that claim. We used to do a lot of publishing of claims, but now most of that has been taken away, amended out of the law. We still have one section of law that requires publication of claims. It does say that you have to publish at least 3 days before issuance of warrants for payment, any claims for allowances made by the courts. So you have that requirement. It also requires that the allowances have to be published within 60 days after the court made that allowance. So you have that 60-day window to make sure that you get it in the paper and it's 3 days before you actually send the warrants out. So you would send the warrants out maybe on the 63rd day. There are some exceptions to even the court allowances, things like salaries, I think you know that, per diem of jurors, any salary that's in the salary ordinance or salaries of court officials are exceptions to this publication requirement. I think that the AIC has also talked about this being one of the things they want to work on as getting even this part taken out of the law in the future. It's expensive, and if they're only getting part of the claims in the paper, I'm not even sure how valuable that is. There are probably other ways that you can notify those in the public that like to follow these things by putting it on your own website or something less expensive than paying for all these publications. But for now, it's still in there. Yes? Sure. Her question is that on this slide we've said that what you have to publish for these court allowances is the amount to whom it's paid and for what purpose. And she asked if that is a new section of law because it hasn't been something that Board of Accounts has audited that she's aware of. They've never commented that you're not doing this. It's not new. It's been in the law for quite some time. I think normally For one thing, we don't audit from the publications. We're looking to see that you complied with the statute materially. And sometimes just by, when you had commissioner claims, you would do it by department. You might have, the sheriff paid this vendor, this utility, this person, and you'd have the amounts. And so for the sheriff's department was the purpose. And we weren't going to get down to, well, how many words do you have to put in the paper to really be descriptive of that purpose? It gets expensive. So now that we're doing just court allowances, take a look at your notices. The law does require the purpose to be in there, but we also understand from an audit perspective, brevity is money. So we want you to be able to be concise in what you decide to publish, and we will try not to be overly critical of what you decide is significant description of that. I mean, now it's all for the courts, but, and sometimes the vendor tells you what it is. If it's, that you're paying power and light, you're paying power and light. Okay, it's electricity. So know that that's in the law, but just make it what you think is sufficient to satisfy the law without being overly burdensome in cost. And we'll try to not question your judgment, but just question that, okay, how did you comply? This is what you decided? Okay. We want you to be aware of it, but we don't want to question your judgment on how you complied. Okay, law keeps talking about this allowance of claims. We all talk about approval of claims. Same thing, but that's the terminology that they've chosen to use. This particular section of the law says that the county executive may allow or order payment of claim only at a regular or special meeting of the executive. So yes, they have to meet. They can't email each other and say, well, this is a claim that's got to get out the door. Let's all say it's okay. A county scared me that way. A county treasurer scared me by including me for some reason on an email that asked the commissioners, that 2 of them, give a signature because they needed this vendor to be paid. And I understood the urgency. I didn't understand why she copied me on the email. But of course it scared me. And I thought, please don't do anything that you can't do. Don't approve a claim if you're not at a meeting. I was told that my fears were unwarranted and that they had a meeting and it was approved. I suppose they must not have gotten some signatures that they needed or something at that particular session. It also says that the auditor may only issue a county warrant for payment of a claim against the county if the executive orders you to do so. And it says that the executive may allow a claim if the claim complies with IC 51110 1.6, which we are going to talk about later. It's a very important statute for auditors. And it also has to be placed on the claims docket by the auditor at least 5 days before the meeting at which the executive is to consider that claim. Now, these are the provisions for your regular claims, not your court allowances that we just talked about in your publication requirements. Because obviously that allowance has already been made by the court. It goes on to tell us that in that section that a violation of this section, so we're talking about Section 4 of Chapter 6, Article 2, Title 36, is a Class C infraction. An auditor who violates this section is liable on their official bond for twice the amount of the illegally drawn warrant, which may be recovered for the county by the taxpayer, and a taxpayer can bring action to recover on one of these illegal or unwarranted or unauthorized allowances by demanding a refund by the county executive within 60 days. So there's some pretty serious language in these claims statutes. I know it's old, but there really are some serious ramifications if we don't understand why we're doing certain things and we decide that it's okay to skip one of those functions. So we don't want to do that. Make sure that your claims are allowed by the proper body, the court or the commissioners. Now, there's an exception to every rule, and there was an exception written into law for claims to allow them to be paid in advance. You can see the statute where that exception is written, and an auditor is allowed to pay claims in advance of board allowance without making one of those Class C infractions when the county executive has adopted an ordinance allowing money to be dispersed for lawful county purposes. Each payment has to be supported by an itemized invoice or bill. It has to be certified by you. This is the first time we're talking about your approval in the auditor's office, which is called a certification. Also, you have to present those claims to the executive at their next meeting for their approval. Oh, how'd that picture get there? That's the picture of Debbie and myself last year when we obtained 100% completion of annual reports being submitted through the gateway. We decided to revive the picture. It's my screensaver because I am very proud of all of your hard work. We did not give you a lot of training, and the program was not done in advance to really work with the vendors. The vendors in the room, I thank you. I thank all of you sitting out here for the work that you did to not only get your annual report information put into Gateway, but also many of you helped your township officials and others to also comply, and we so appreciate it. It is a big goal for this transparency that the administration has promised the taxpayers, and none of you are opposed to that transparency, but not everyone realizes the work that it has taken to get that information out there on the web, and we really do, and we really appreciate it, and I thank you, I commend you. I'm so proud of you for being the first ones to get done 100% each year, and I'm very happy that Debbie and I have not had to sit in on any of those meetings when any of you got a subpoena from Paul Joyce to come visit us in the office. We've not experienced those meetings, don't want to experience those meetings, so thank you for saving us from that. It's kind of a boring claims presentation. I just wanted to give you a little something to keep going this afternoon, okay? So with that, we'll go ahead and just mention that there are some other sections under Chapter 6 that apply to very specific claims, supplies that are purchased by contract. Some of you don't accumulate all your supplies anymore and issue a contract for those supplies. Some of you do. If you aggregate your claims and have a contract issued for supplies, then you have a specific section you need to follow under Chapter 6, and it's mentioned there. Also, if you have any county institutions like a county home, any of those situations, there's specific legislation on those claims. There's a specific section under Chapter 6 that talks about claims for work on a contract. It's not so much different from every other claim that you have to audit, except for if it's work that was to be conducted under supervision of one of these officials listed in the slide, like the surveyor, engineer. And then only if that supervisor certifies in writing on the claim that the work listed has been performed according to the contract and claim is due and owing, may you go ahead and certify that claim for the board to allow, the Board of County Commissioners to allow. And once again, that certificate has to be in writing and it has to be filed with the claim. Let's talk about payment of claims. Claims have to comply with IC 5-11-10-1.6. I say that statute a lot because I give that statute to people a lot. It is just a very, very important statute, so it's one of the next ones we're going to talk about. Also, it has to be filed with the auditor more than 5 days before the meeting of the executive at which it will be considered. And that is so that you can get it on the claims register or claims docket, whichever you use in your county. Law talks about charging the appropriation. Whenever an auditor draws a warrant for a claim, he shall charge the claim against the appropriation made for that purpose. Now, you all have been through budgets. You've seen your budgets. You've entered your budgets into your financial accounting systems so you can track what the appropriation balances are. And you know that if you looked at another county's budget, your minor classifications under the budget are different. There's not a uniform set anywhere. I looked when I did chart of accounts. There's major classifications, and those are uniform. There's some minor classifications listed, but there's a whole lot more object codes that you use in your county that are not on a list anywhere except for in your county. So when you call me to say, can I use 1000-100-206 for XYZ, I don't know. We have to understand the budget that you put together and your council adopted. And that is for you to understand, but the claims deputy also has to understand it. I don't know if the appropriation in 206 was made for that purpose of that claim. There's some things that can tell you right away it wasn't. You can look at the language of that major classification and minor classification and sometimes tell right away that's not the right fund or that's not the right appropriation line. You can't pay for developing film out of the personal services line. But there's a lot of things that are not as clear. So it's very important that the claims deputy have some guidance on what was approved in the budget, and not just in the auditor's office, but the other offices as well. Because the claims deputy is the one that's protecting you, the elected auditor. Also, if the claim is for materials, supplies, or labor for more than one officer, the auditor shall apportion the claim and charge the proper amount against the appropriation for each officer. And then any similar apportionments shall be made in other cases. So the law directs the county auditor to apportion the claim and charge multiple appropriations when the claim is for goods or services for more than one officer, more than one departmental budget, more than one fund. And so be mindful that that is something that was written into the law as the auditor's obligation. And you know, there's many times when you'll call and ask us, can we pay for the GIS out of the reassessment fund? Well, who all's using the GIS? Well, it's replacing the plat book, and the surveyor uses it, the assessor uses it, the highway's going to use it. Well, here's our answer. This is why we answer that you have to decide what is a proportionate share for each of the appropriations you have available to spend on that GIS system. So it is proper for you to help make those decisions about proportioning charges against different appropriations. Okay. We're finally up to the statute I really want to talk about. There are requirements for the issuance of a warrant by a fiscal officer, and they're in this statute that I keep talking about, 5.11.10.1.6. And what it says is the fiscal officer may not draw a warrant or a check for a payment of a claim unless there is a fully itemized invoice or bill. The invoice or bill is approved by the officer or person receiving the goods or services. So that's the department head that signs off on the claim. There's a place on the accounts payable voucher for that. The invoice or bill is filed with the county's fiscal officer. That's you. Fiscal officer audits and certifies before payment that the invoice or bill is true and correct, and payment of the claim is allowed by the county executive. Now, number 4 is your responsibility, and it's also your protection. Remember, we said that you are required by law to present claims to the commissioners for allowance. If you audit it and you find a claim is deficient in one of these areas, or it is not got a proper appropriation, it's going to make your appropriation be overdrawn. Or it is from a fund that does not allow that type of disbursement. I recommend you notify the person who submitted the claim to tell them of your objection. If they insist that you give it to the commissioners, here's your protection. Consider strongly whether you want to certify that claim. You may want to present it without your certification and present your reasons for not certifying when you present the claim to the commissioners. That's your protection under the law. Some more things that are in this same 1.6 section. This is in 1.6D. The fiscal officer does not incur personal liability for disbursements that are processed in accordance with this section, all of 1.6, and for which funds are appropriated and available. Remember back in our first Back to Basics session, if you were auditor then, we talked about appropriations and what they are, and we talked about making payments on warrants, and we talked about funds and the different types of funds. And one of the things that we said about disbursements when we got to the disbursements category is that it takes appropriation and cash to be able to spend. Counties should not have appropriations that are overspent, and they should not overspend cash balances. So those are two things that you need to look for in addition to auditing the claims documentation under 1.6 to make sure that you can avoid personal liability. So I was asked a question just this week on whether it would be okay to spend an appropriation into the red for payroll because they knew they needed to do the payroll and they had miscalculated during budget time the budget appropriations and they had not appropriated sufficient monies. Yes, that can be a very serious mistake, and we all make mistakes. But spending the appropriation into the red and then fixing it by the time it's year end is not the proper way to handle it. The proper way would be for the county fiscal body, which is the council, to go in and make a transfer of appropriation within that same department so it doesn't have to go to the state for approval, and give yourself time to pay the payroll and get the additional appropriations needed. There is a way to fix it, but we need to make sure it's not just by spending the appropriation into the red. Do remember that appropriation is a big word, but all it really means is that you have permission to spend. This slide's going to be a little difficult to read, but it's not that important that you be able to read it at this point in time, other than the title. We have published several times for as many years as I've worked with counties when what we know as the commonly used exceptions to when an appropriation is required. It's almost always required unless you meet one of these statutory exceptions, and so this is basically copied right out of the county bulletin. The most recent article on this is in the County Bulletin, volume 372, page 6, which is from April of 2010. So it's not too old. Do you have a question? Okay. So keep in mind that you can always look to the County Bulletin to find some of those common exceptions. And I strongly recommend that your claims deputy include in their standard operating procedures manual that they're going to put together with your help, that they document the law under which appropriation wasn't required right on the claim or the invoice or bill that's attached to it, so that you have the reason why you didn't check the appropriation line or there isn't an appropriation or why it's being paid out of unappropriated dollars. Right? You have the reason right there. You don't have to look it up a year later. And so that county bulletin article, they may want to copy that, put it in their manual so that it has the statutory references right there in the bulletin article to help them to do that on the claims. Some of the required claims documentation, which is also an auditor's responsibility to make sure is there, is that the documentation has to show evidence of approval by the officer receiving the goods or services, which is one of the things we talked about in 511.10.1.6. It has to show evidence of the audit in your office and the approval of the dispersing officer, which is your certification, and then also documentation of the allowance of the Board of County Commissioners. And this can be a signature on the accounts payable voucher, the Form 17, or more likely, it is that you use a claims register of claims, claims docket, any of those titles, which we call our prescribed Form 364. You probably have an automated computerized form that you use for your claims docket. And as long as the signatures of the allowance of the commissioners is on that claims register, you do not have to have individual signatures on the Form 17s. Now, it does say in the law that the register of claims has to be filed with the supporting invoices or bills and be preserved. Many of you don't automatically file them in the same place. The claims are normally a form that it folds a certain way and you can see the claim number and it goes in a specific type of file, and the docket doesn't necessarily do that. So some of you were telling me you put it in a book for that purpose, and I doubt you, if you're doing that and you reference these claims were paid on this claims register, and you can go back and forth from the register to the claims or the claims to the register, you've probably not had an audit issue, and we would consider that compliance with the statute. May not physically be with it, but it is with it by reference. There is an appeals process, and I've had to reference this statute at least once for an auditor who did hear from an aggrieved person that they were upset that their claim was not approved by the Board of County Commissioners. That is not your choice. If the commissioners disallow a claim or a part of a claim, maybe you recommended it, but it still was not your decision, and you cannot change it. So the process is not to come to the county auditor and complain. Here's the process in the law. They have to file an appeal in the circuit or superior court. They have to file within 30 days of the commissioner's decision. They have to include a bond covering court costs and making that bond payable to the county commissioners. If there is no increase in the allowance by the court that the commissioners originally made, then the appellant shall pay the costs of the appeal. So they'll cash the bond and they'll pay the court and collect the court costs. This is the recourse for a person that has been aggrieved by a decision of the Board of County Commissioners. There's also some conditions for recovery of what the statute refers to as illegal payments. Money that is paid in violation of 36-2 may be recovered by the county executive bringing action in the name of the state, which is kind of unusual. They have 30 days from the date of the payment that they feel is illegal or in violation to bring that action. A taxpayer can demand that the commissioners bring that action if they feel that the county has been harmed or the taxpayers have been harmed. And then the courts are to award the amount of the illegal payment plus 6% per year to the county and attorney's fees and expenses to the plaintiff if a successful action is brought. I've never heard of this actually being used, but please do be aware of it. I would also like to say, or just to emphasize and bring out, many of you may know this, but I'm sure you quote it all the time to department heads and other office holders that want to spend without appropriation. But Indiana Code 36-2-5-2, subsection B as in boy, says that money may be paid out of the treasury only under an appropriation made by the fiscal body, except as otherwise provided by law. And we talked about those exceptions that were common in the law for things like the Recorder's Perpetuation Fund and those kinds of things, and that's all in the county bulletin. But what I want to bring out is that your commissioners, by home rule ordinance, cannot circumvent this law. They cannot have a home rule ordinance to establish a new fund and say it doesn't need appropriation. This law says everything needs appropriation unless you have a statute that says you don't. Okay, so I just wanted to make that clear to everyone that may be going through trying to work with all the office holders and also your commissioners and council to get the county's work done. I want to encourage you once again to work with your claims deputy to print out these statutes, take that county bulletin article and start building some kind of procedures manual for certifying claims on your behalf as auditors, because it is important and we don't want to see anybody experience any kind of personal liability for something that was not audited properly or any of these other recourses that taxpayers have to come against you for claims that weren't allowed. So with that, I am going to turn it over to Debbie, and she's going to talk about new legislation.